of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws.
So with that, is there a passage or quote or question that somebody would like to bring to the table to just start us off?
All right, I have something on page 201, at the very bottom, on the history of the right to counsel and the action of the 14th Amendment, it says, "No rule for the conduct of the states, the question recurs whether the constraint laid by the amendment upon the national courts expresses a rule so fundamental and essential to a fair trial, and so to due process of law that is made obligatory upon the states by the 14th Amendment." Does anyone have anything to say about that, or would like to rephrase it in any way?
That one had to do with the second question of the teamwork question, because if you go just to the top of the next page, so what Tali just read, I believe, was a little excerpt from Betts versus Brady case. So then at the top of the second paragraph it says, "We accept Betts v. Brady's assumption based as it was on our prior cases that a provision of the Bill of Rights, which is fundamental and essential to a fair trial, is made obligatory upon the states by the 14th Amendment." So that was the part of the ruling from that case that this court agreed with, saying that the 14th Amendment is what makes it obligatory to follow the Sixth Amendment.
So, wouldn't that, like, if Betts versus Brady was decided before Gideon versus Wainright, wouldn't what they said there in the quote that Tali read, in Betts versus Brady, wouldn't that make Gideon eligible for an attorney?
Well,
Why didn't he get one then?
So the following sentence after what Abby read on 202, in the second paragraph, is, "We think the court in Betts was wrong, however, in concluding that the Sixth Amendment's guarantee of counsel is not one of these fundamental rights." So in Betts, they acknowledge that the 14th Amendment can be used to implement the Bill of Rights to state jurisdiction, but they also concluded that the Sixth Amendment didn't fall into that category, so they completely countered what this case sets as precedent.
I don't get how they can conclude that the Sixth Amendment isn't a fundamental right.
I think like there's just a little quote at the top of 202 that like I think is kind of what they talk about. It's like, appointment of counsel is not a fundamental right essential. Wait, never mind. I think like what I interpreted them saying that as, like, I don't think that's really what they meant, was like it's not a fundamental right, but it is essential to a fair trial.
So are they trying to say, is this kind of saying like a fair trial isn't like a fundamental right?
Yeah, I guess so, which is wrong, because if
they were saying that, just to sum it up a little bit, was that they agreed with the Sixth Amendment except the last line. Okay. So they said they agreed with everything it said to say that everything is essential to a fair trial other than appointment of counsel.
Okay.
Right. Which I agree, I also don't understand how
Well, that was in the previous case in Betts.
Yeah.
Can I ask a question that's kind of in a different direction? I have a question about like the application of the 14th Amendment. How like it doesn't just like it was in the case we did before this also, and like it was violating the Second Amendment as well as the 14th Amendment, and I understand they go hand in hand. But shouldn't we just not be able to violate the like amendment that like talks about it? Does that make sense? Okay.
That's kind of what I was trying to ask during the last Harkness, when I was like, does this violate two amendments or one amendment that like we were touching on, couldn't figure out how to phrase, because it's like, yeah, that's all I have to say.
Where in the text does it say? Does it talk about the 14th Amendment?
I was just referring to the holding decision where it says the petitioner's trial and conviction without the holding on page 200, holding decision. The petitioner's trial and conviction without counsel violated the 6th and 14th Amendment.
has to be the
There.
action. Oh, and then, yeah, there's. Wait, that's not.
This has to do a little bit with selective appropriation.
Yeah, I found it.